Hi everyone, Bryan Cermak here with another episode of Life, Law, and Lessons. Today I want to talk to you about a legal theory called negligence and how it is used in civil law, not only in Michigan, but in all 50 states. Negligence, by definition, is the failure to act appropriately as a reasonable person would under the circumstances that you're presented. And if somebody has been negligent and causes some injury, that person or that company can be sued for their negligence. Every lawsuit in Michigan, there are certain elements you have to prove to win your lawsuit. And negligence is no different. There are four elements to a negligence cause of action. And to win the case, you have to prove A, there was a duty owed by either a company or an individual to a third party. B, you have to show that that individual or company breached their duty. In other words, they failed to live up to what was expected of them, or they acted negligently. C, that the breach of duty was a proximate cause of damages to someone else or to a business. And then finally, D, that the business or third party was actually harmed or sustained damages. So you have duty, breach of duty, proximate cause, and damages. Any one of those elements can be the subject of a separate lifelong lessons episode. So this is the first of three episodes where I'm going to examine everything from top to bottom about what you should know for a negligence lawsuit. Again, today all you need to know is you can sue for negligence or you can be sued for negligence if you fail to do what is expected of you or what a reasonable person would do under the circumstances. And the elements are duty, breach of duty, proximate cause, and damages. In our next lesson, we're going to talk about that funny phrase, proximate cause, and what it really means. Please tune back next week for episode 2, where we talk about proximate cause.